Mr. Voorhoof is a professor at the University of Ghent and at the University of Copenhagen. He's an expert in the field of media law, media information, and he'll be speaking to you today about the freedom of expression, media, and responsible journalism. Please give Mr. Voorhoof a warm welcome.
Thank you, and thanks for the organizers for bringing me to Kortrijk, where I don't come that often, and it was very nice coming here. I would like to talk to you and give an introduction. I think it's good that it's at the beginning of the afternoon to draw the attention to some elements of similarity between law and journalistic ethics, between regulation and professional guidelines that the profession itself has developed. And I would like to do that from the angle, from the perspective, how the European Court of Human Rights is looking at the issue, on the one hand, of freedom of media, freedom of journalism, and on the other hand, a request for responsible journalism, how that became element of the attention of the European Court. I don't know each background in this, but I would very briefly like to introduce the importance of the European Convention on Human Rights and the article which reflects the freedom of expression as a European standard, first very briefly. Secondly, I would refer to some of the judgments, some of the decisions by the European Court dealing with journalism and professional ethics. And then we'll see how much time is left. I will give one, and if possible, two examples with short exercises where I would like also to have your input, to look at a few cases, a few problems, and to find out how law and journalistic ethics relate to each other, are in harmony with each other, where they can conflict with each other. To start with, we can best start by using the force of our national hero, Tintin, and to discover this complex issue of law and ethics and European law. Very briefly, I'm sure you heard about the Council of Europe. In contrast with the European Union, the Council of Europe is the big Europe, containing for the moment 47 member states, in which the most important instrument is the European Convention on Human Rights. It's a common European standard we agreed on after the Second World War in order to upgrade and to secure a very high level of respect for rights and freedoms. Right of privacy, right to fair trial, to be protected against torture or inhuman treatment, but also the right of freedom of expression. And that's Article 10 of the European Convention. Sometimes we call it Europe's First Amendment, because it became clear the last 30 years that this article in the European Convention is not just hanging there somewhere in that European treaty, but has a far-reaching impact on the daily life of media and journalists of all 47 member states of the Council of Europe. Because this article guarantees freedom of expression and information without interference by public authorities, unless under very strict restrictions, under very strict conditions, some sanctions, some restrictions are possible when this is necessary in a democratic society. And of course this is a very vague and open notion. What is necessary in a democratic society in order to curtail, to stifle freedom of expression, to restrict freedom of the media, to punish, to sanction in some cases, editors-in-chief, publishers or journalists. So we need to look at the case law, the jurisprudence by the Strasbourg Court, because that I need to mention here in the beginning as well, as you probably know, that the European Convention on Human Rights is not just a convention, a treaty on paper. We have developed in Europe tools in order to secure that also in real life these rights and freedoms are protected and secured. And something can go wrong in some member states, some authorities can be disrespectful for rights and freedoms. And that's why we have the European Court of Human Rights. We have developed this court, we have given it additional powers. There is a right of individual petition, so that every citizen, every journalist, every publisher who feels in his or her country to be restricted in an unacceptable way in its rights and freedom of expression, they can go to Strasbourg and hope that European Court finds a violation of his or her right, that the domestic authorities did not protect at a sufficient level freedom of expression. So this convention is applicable from Greenland being part of Denmark until Azerbaijan. It stops at the border with Iran, from Norway to Cyprus, from Ireland to the most eastern part of Russia, because Russia is also a member, a problematic member of the European Convention. You probably know that there are 2 places in Europe where the European Convention is not applicable. Just that you are aware, if you go there as a journalist, your rights will be less protected than compared with the 47 other member states or states in Europe. 2 places in Europe where you have to take care, not under the umbrella of the protection of the European Convention on Human Rights. Who knows where the dangerous areas are in Europe? Yeah.
I don't know. Russia?
Russia is a member. Russia became a member nearly 10 years ago. There's a lot of violations. I totally agree. It's very dangerous in some areas, especially the human rights area and intelligence area, or criticizing Putin. You only need to sing a song in a church and it can cost you an imprisonment. But Russia still is a member, so we hope also that in the future, under the pressure of the court's case law, also Russia has to improve the standard of freedom of expression and better protect journalists, because very many journalists have been killed, assassinated even, because just doing their job. So it's not because the convention is applicable that it's absolutely safe, but you can be sure where the convention is not applicable, the situation is even worse. So what could that be? Belarus, the regime of Lukashenko, the last dictator of Europe, where it's very bad living for independent NGOs, human rights activists, but also journalists. There's one more spot, maybe for other reasons they're not a member of the convention. Yeah? Kosovo, that's a very good answer, because I wasn't thinking in advance at Kosovo, but of course you're absolutely right. Kosovo is under a specific international statute and is no member for the moment, although they apply the European Convention standards. They have in their constitution, and are you from the region? No, no, it could be. They have in their constitution an article which says that they apply the European Convention on Human Rights. So not many people know the situation in Kosovo that well. It seemed that you knew. Now, one more spot. I need to tell it myself. It's the Vatican. It's not that they are torturing people there. What could be the reason that the Vatican is not a member of the European Convention? It was in discussion this weekend again. There's an obvious reason. It's not that they torture people. The situation in prison is not that bad in the Vatican. But what would be the main problem in terms of human rights?
I don't know, because it's ruled by church.
That day?
It's ruled by the Pope.
Yes, and was a problem to be ruled by the Pope? Because other countries are ruled by a king.
I think they have laws, but I don't know the Bible is.
Yeah, so there's a problem, the freedom of religion. But specifically, what is the main problem? And as long as that problem is not solved, the Vatican could not become a member of the European Convention. You have an idea?
It's not a democracy.
It's not a democracy. Yeah, that goes a bit together with that the state under the rule of law is not profane, but under religious elements. But maybe it's a man who will give the answer. Discrimination, Article 14 of the Convention. You're not allowed to discriminate between men and women. And I heard that the Archbishop of Belgium this weekend said that they have no intention to change that. Okay, that European Convention, I can't get too long in it, and in that convention we have this very important Article 10, which has been used on the many occasions under domestic proceedings, and in a few cases also journalists, persons, publishers went to Strasbourg, because it's in Strasbourg that this European Court is established, to initiate a complaint against their country. For the moment, there have been more than 1,000 decisions by the European Court in Strasbourg related to media, journalism and freedom of expression. And in hundreds of them, the European Court found a violation. So it's interesting to be aware that the court has upgraded the level. It's not sufficient, the existing level in many member states. Applicants who take their case to Strasbourg can win a case and can find out that in their country there had been a violation, a breach of this article, because the court again and again considers that certain sanctions, certain interferences were not necessary in a democratic society, that you have to give sufficient space to freedom of expression, which is an inherent characteristic of a democracy. It started in 1979 with the first case ever. The European Court found a violation in Sunday Times case. Sunday Times, a very well-known weekly magazine, announced to publish a set of articles on the so-called thalidomide case, Softenon, a kind of a pain stiller taken by pregnant women, and it turned out that many handicapped children were born, many died during birth or very short after. Hundreds of families were victim of having used this new introduced aspirin, you could say. So court cases started for damages because the firm didn't do sufficient research and development on this. And before the before the case was dealt in court, the Sunday Times announced a very thorough set of articles on the whole issue, interviewing all people involved, public prosecutors, police, researchers, people of the firm, distillers, victims, etc. And the firm who produced the aspirin went to court and asked for an injunction, which is an order by a judge prohibiting that the articles could be published. And that's what happened until the highest level, the House of Lords, now the Supreme Court in England, decided that it was not for the newspapers to develop all arguments which later should come to court, trial by a newspaper. And that was considered as a kind of a contempt of court in the United Kingdom. It's a disrespect towards the court, who still needs in full impartiality to decide on the case. But still, Sunday Times, with some good lawyers, they took their case to Strasbourg, and the Strasbourg court came to the conclusion that there is something like the right of the public to be properly informed, specifically with relation to issues of public interest, like, of course, this issue absolutely was, having involved so many people being the victims of this. So that was a very important start, and from that moment on, I can just refer to very few of the landmark cases. For instance, a journalist from Austria took his case to Strasbourg because he had been convicted for criticizing the former chancellor of Austria, kind of a prime minister of Austria, who was criticized because he had worked together with former SS officers. So that's not that nice to build up your career with as a Democrat. He revealed this. He connected to that some very negative value judgments. He was convicted for defamation in Austria, took his case to Strasbourg, and the court said, well, this should be allowed in a democracy, to reveal such cases and sharply to criticize. The facts were true, and the value judgments were very sharp, but that you have to accept in a democracy. You cannot request that value judgments can be given evidence of. And that's the essence of an opinion. That's not susceptible of proof. You have also to look at the political context. The role of the media as public watchdog was a notion that has been introduced by the court, and it was clear that the journalist had acted in good faith. He had checked the information, so that should absolutely be acceptable, and that was considered again a violation of Article 10. Another example to make clear what the input has been and the added value that the European Court has created in this area was a case against Denmark, where Mr. Jersild, a senior journalist, maybe to compare it with William van Laken or maybe Tim Powels of the VRT, a well-respected journalist, made a program on upcoming racism in the capital in Denmark, in Copenhagen. And he interviewed some extreme, radical, right-wing, young people belonging to a group which called itself the Grønjakker, the Green Jackets. And in some of these interviews, they were very disrespectful towards foreigners, black people, people from the Arab world, very denigrating, very racist terminology. That was broadcasted on DR, Danish public television. Many complaints came in, also to the public prosecutor's office, and both the Green Jackets were prosecuted and convicted, but also the journalist for inciting on a public platform to racial hatred. And Jersild took his case to Strasbourg. After all courts in Denmark, he has exhausted all national remedies. He went to Strasbourg, that the court said, this is not okay to punish a journalist because of what the interviewees have said during the interview. Especially when you have to look at the intention of the journalist. The intention was absolutely not to incite to discrimination and racial hatred, but to bring under the attention of the public what was going on in Copenhagen. You need to take a look at the context, and what is very important, I think, for future case law and the relation between law and ethics is that the court said that it was not the task of the European Court, and it's neither the task of national courts to substitute their own views to those of the press of what technique or kind of reporting should be adopted by journalists. In other words, the judge should not take the chair of the journalist. It's two different kinds of jobs you have to fulfill. Article 10, and the court continued, protects not only the substance of the ideas, but also the form in which they are conveyed. So that also gave some extra margin of independent evaluation of professional obligations for journalists. Where law and ethics started very clearly, obviously meeting, is on the issue of protection of journalistic sources. The first judgment of the European Court in this area is the Goodwin case. William Goodwin was a young trainee journalist working for Financial Magazine in the United Kingdom, who at a certain moment was ordered to reveal his sources in a case that he wanted to report on. He refused. He said, look, I studied journalism studies. I learned from my professors and from some guest speakers in journalism that it's maybe the first principle of journalism not to reveal your sources. You protect the confidentiality of your sources, and not a policeman, not a public prosecutor, not even a judge or a court can overrule this ethical rule. So that was his point of view. But the British courts had another point of view, and they found that there were reasons to compel him to deliver a document that possibly could reveal a source, that could retrace the identity of the document. So he was convicted for contempt of court, showing disrespect towards an order by a British court that you don't want to execute. He had to pay a fine, was confirmed at the highest level. He went to Strasbourg, and the judgment in this case clearly demonstrates how a living and dynamic instrument Article 10 is. Because if you read Article 10 of the Convention, there's no reference at all at protection of journalistic sources. So the European Court was very creative in this case by admitting that freedom of expression includes also press freedom. There can only be press freedom when the journalists can work not only with official information, but also with information that they get from different informal, confidential sources. So there is no flow of information without sources. And that was also then what the court recognized very explicitly in this judgment, that it said that protection of journalistic sources is essential for press freedom. So it became part, source protection, of Article 10 of the European Convention. It's not an absolute right, and the court said that there can be overriding requirements in the public interest to compel a journalist to hand over some information, maybe to prevent terrorist attacks, to secure the physical integrity of persons, but not in this case, which was on a conflict within a firm. And as you can see, at many other occasions, the court found that in these countries there was no sufficient protection of journalistic sources. And it's not in Bulgaria or in Moldova or in Russia or in Azerbaijan. As you can see here, it was in Western Europe, in Belgium, in Luxembourg, in the Netherlands, in the United Kingdom, and in France. 2 cases of this year, Martin and other, and Ressiot and others versus France, which is related to the doping scandal in France, where newspapers used leaked information. So that became very interesting to see that even in countries with a very high level, it is assumed, of press freedom, there can be gaps in the system in order to protect journalists. So you could say here that due to the case law of the European Court, these states, but also all other member states, have to upgrade, have to secure in their legislation, in their practice, higher standards of protection of journalistic sources. So the impact of this judgment and the later judgments is enormous in terms of journalists being able, in reality, to protect the confidentiality of their sources. And a bit in line with this is also the case of Le Canard Enchaîné, you know, a satirical weekly magazine in France that published at a certain moment confidential tax files of a CEO of a big firm in France, where a social conflict was taking place. They published the tax files of the CEO to demonstrate, to give evidence of the fact that the management refused to give a minimal uprise of the salary of the workers, while the management itself and the CEO specifically had raised their income, their salary, with more than 60% the last 3 years. So that was very relevant to understand the social conflict in that company at that moment. That's why they published these tax files. When they published it, there was a complaint. The journalist, editor-in-chief, Frezot and Roire, the journalist who published and commented the whole article, they were convicted in France for breaching the confidence of secret information and for using stolen information, a double incrimination. But the European Court found that it is indeed a principle that journalists are not above the law. Like everybody, we are obliged, also as a journalist, to live according to the provisions specifically of criminal law. But the court said, in the interest of the public, it can be more important to secure the right of the public to be informed than the enforcement of criminal law. And in this case, although there was a clear provision in criminal law in France, the court decided that this provision should not have been applied because there was a higher interest involved in what the journalist had been gathering as information and producing to enlighten the public of what was going on. So it was considered, this conviction of the two journalists, a violation of Article 10. The same happened in a case against Slovakia, where a radio broadcasted a conversation between two politicians, and it is clear that this conversation was illegally tapped. Again, here sufficient reasons to use that material, to broadcast it, and not to be prosecuted, not to be convicted. Otherwise, violation of Article 10. So what we can see here is that in many judgments, the European Court of Human Rights refers to the finding that a journalist was fulfilling his or her task as a journalist and had also been working according to the standards of the basic rules of his or her profession. So it takes into consideration as an extra defense for the journalist that one has acted according to standards of responsible journalism. So that's why I would like to look at the case with you in which the European Court made a decision in 2005, and the facts are as following. I don't know if you know, but in Denmark, in the Christmas and New Year's Eve, there's a lot of firework. There's a lot of firework on the market, and there has been a big explosion a few years ago in Jutland. There has also been a very big one in the Netherlands, in Enschede. So it's very risky. Also every year there's a lot of casualties using this dangerous firework. So the Danish authorities have sharpened the legislation in a way that you need to be a certified expert to transport and to handle firework, and only very minor sets of firework can still be purchased as an individual. But the journalist found out that this was not the case, this was not the reality, that even after the big accident it was still possible to obtain in an illegal way large amounts of very dangerous firework in Denmark. And they wanted to prove this and bring this under the attention to highlight the lack of control by the authorities and the danger in actual contemporary society in Denmark on this issue. So what they did, sorry, I'm in another case here. Oh, I'm confusing two things. I skip immediately to that one. That's fine to take that one. Here we are, and that's what I did. They made a documentary about it, and they went buying some of the firework. They went into a shop, they bought a lot of firework, they loaded it into a van, and they took it on transport. They drove through the capital in Copenhagen. They delivered it at the police office, and the police said, wow, this is something. Yes, it seems that there's no very good control, but at the same time they made a notice and they said that the two journalists would be prosecuted for illegal transport of firework. The program was broadcasted, but the journalists were also prosecuted on the basis of the new amended legislation regarding fireworks, and they were effectively convicted in their country. So what would be the arguments here in terms of journalistic ethics? Would you say this news gathering by the journalists should be saved? This was a kind of responsible journalism. This was in order to inform the public. I think about the Ursilt case, think about the Frezo and Roar case. In some circumstances you are allowed to do something unlawful or illegal. Or would you say now there are arguments here that this was not a lawful, and maybe eventually you have arguments to say this was not an ethical way of dealing with this important issue, which surely is connected to a matter of public interest. Maybe first some negative arguments to disapprove with what the journalist had done. Are there arguments in law or professional ethics that could bring you to the conclusion, I would never do that, journalists should not do that, this was unacceptable? What would be the arguments? Do you follow the Danish police? Or maybe first then, the negative arguments, you have an argument?
Maybe it was a little dangerous.
It was?
Dangerous?
It was dangerous,
If
yeah.
they had an accident or something.
But firework is dangerous, yeah, yeah.
That's maybe a reason why not to do it.
How
That's
could-
also the reason why it's forbidden, probably.
Yeah, so they should have made that program too dangerous. Stay away from dangerous areas.
Done it, but yeah, that's
Yeah.
what it is.
Yeah, because it was dangerous. Is that an argument as such for journalists to stay away from danger and not to get involved in dangerous situations themselves, but even more to make that other people are not brought in danger? Because that was indeed the case here, and that's what you refer to. Would that be a sufficient argument? Other negative arguments, maybe? Yeah?
The citizens first and journalists second. If you're, just because you're a journalist, by your profession, you're not exempted from the laws of the country in which you work.
Uh-huh.
Your first responsibility is to be a citizen,
Yeah,
guided by the laws of your
yeah,
municipality,
Yeah.
region, country.
yeah.
And it's kind of arrogant for journalists to think just because they're employed in a particular career or profession,
Uh-huh.
they're exempt from laws that bind all the rest of us.
Yeah. And also, what the court said as its first principle, journalists are not above the law, and according to you, they should even be appropriate citizens.
I'm just suggesting.
Your argument, eh? Yeah. Okay, let's maybe go the other direction. What arguments could be used in support of the journalist action in Strasbourg, because the case was taken to Strasbourg after they were convicted in Denmark, to justify, to legitimize this kind of action? I see there are already a few more fingers in support of the journalists. Yes, please. Yeah, yeah.
Everything they did was in function of the investigation, which was in public interest.
Uh-huh.
That's kind of the fault.
Yeah, everything they did was in function of the investigation. The investigation was in the public interest, hence all the activities were justified by public interest. More arguments? Yeah,
I think it was just necessary that they break the law in order to protect.
yeah. It was necessary that they broke the law, otherwise they couldn't have demonstrated that it was possible without being certified to purchase that kind of dangerous firework. It was a particular dangerous set of firework that they had purchased. So they had to break the law, otherwise they could never reveal, and then maybe the policy could never have changed in their country if that wouldn't have been revealed, how easy it was. Other arguments? Let's take a look at the outcome by European Court. European Court said that the legislation on fireworks is clearly based on safety considerations. It's not to restrict the activities of journalists. They were also in a possibility to broadcast a program. There was not any restriction on the journalistic activities. But the journalists were not certified pyrotechnicians. And of course, that the journalists they knew. The offense in question could have had serious consequences if the fireworks has detonated by accident during the transportation. So the element of risk is very heavily integrated here, both in the decision of the Danish courts and the European Court. And I think indeed the European Court is right here. Because as professional journalists, they indeed have the task to reveal what is going on. They should find a way to bring under the attention that it's possible, rather easy, to purchase illegal firework. But they should have been aware of the provisions of the Firework Act, that you need to be a certified pyrotechnician. So what they should have done is to contact an expert in this field, and in their undercover investigation, they should have used a certified pyrotechnician. If they wouldn't have done that, then still I think they could purchase the firework, load it in the van, call the police or the fire brigade and say that they just had purchased the material. Then also they had the evidence. It was not necessary for the investigation to ride through the center of Copenhagen, densely populated, with such an explosive material. There the journalists have indeed acted in an irresponsible way, and it was not necessary in terms of material for broadcasting their program. And I think here law and ethics, to my consideration, clearly coincide. If you look at some codes of journalistic ethics in several countries, there you also will find that undercover operations with some minor offenses might be justified in terms of journalistic ethics, but under strict conditions. And it's recurrent to see that two conditions will always be there. First of all, and of course it must always be in the public interest, but the basic condition will be that there are no other methods in order to reveal what you want to reveal, that the public is informed. And secondly, that you don't put the journalists, but also third parties in a disproportionate risk, which was the case here. Somebody had a question or a remark on this case? But I just continued it to make clear what the arguments were. Yeah?
So if they wouldn't transport it to fireworks, and they wouldn't have been convicted?
That I don't know how severe the Danish courts would have been, but I think then the European court might have overruled the finding by the domestic courts, because that seemed to be the crucial argument for the European court. But also, if I read the Danish decisions, that it was not really necessary to transport if you wanted to prove that you could purchase it. So that was an additional irresponsible act by the journalist. So I think this is an example of dealing with law and ethics, and sometimes journalists not taking sufficient consideration of all elements. I wanted to highlight this case, and I see that we still have 10-15 minutes. I can also take the other case that I wanted to start with, and that will take about 15 minutes. And we were in the atmosphere. We stay in Denmark. I don't know for what reason. Yeah, just occasionally it's two cases about Denmark that I have chosen. Maybe it's because my girlfriend is from Denmark, but I don't know. Anyway, two interesting cases from Denmark, and the other one was where a journalist in Denmark got information that there were networks still active in Denmark where pedophiles meet each other, where they exchange information, how to get in contact with young people for sexual abuse. And of course, if you go to somebody and you ask, are you a pedophile? How do you get in contact with minors? You walk in the street in Kortrijk, you won't have much material for a journalistic report. So what he did, he started to go to some obscure bars with a hidden camera and a small microphone. He started to talk with people. He started to win the confidence with some of the people that he heard that were in, participating in kind of a group. Cannot say a self-help group, but they were exchanging information how to get in contact with minors. He went to some of their meetings. He recorded some of the conversations, and of course the other people didn't know that he was a journalist. He worked months on this program. It was broadcasted on television. Many people were looking in Denmark on a Sunday evening to that program. It was really revealing. And of course also the police was looking. So the police got very much interested in the material of the journalist because it seemed that he went very deep into the circles of pedophiles in Denmark. So it could be very helpful for the police to identify suspect people or people who admitted that they were involved in sexual abuse of minors, to identify them, to prosecute them, and eventually to bring them to court. So what would be your perspective here? Would it be, let's say, a traditional legal perspective, universal principle, that everybody can be compelled to help the judiciary to find the truth in order to prevent crime or to solve crime? It's a duty of every citizen in a society. In nearly all jurisdictions in the world, we have this as a fundamental principle. Contribute to the truth finding of the judiciary. Everybody should help to do that. Or would you emphasize here a more journalistic perspective of what we already saw? There's a very basic principle on protection of journalistic sources. I don't want to share information with any police officer, law enforcing body, let it be a criminal court. What would be your position? You refuse to give that information because Nordisk Film and Television is the company who made the program, and they were requested by the chief superintendent and later by a judge to hand over the information. Yes?
I think it was wrong of the journalist to investigate the whole thing and then in the end not tell the police.
Mm-hmm.
Because if they told the police earlier, then they might have been able to act earlier and to stop the whole thing instead of having to watch it on TV and
Yeah. It was broadcasted on TV. There was no prior control, no prior intervention. It was broadcasted, but afterwards the police asked to have access, and later the public prosecutor and the court, to have access to some of the interviews, because of course, that I forgot to say, but it was obvious, I think you understood that the interviews of course were broadcasted with a changed voice, and the image was totally blurred, so that the people the journalists got in contact with were not recognizable. The issue was not to convict certain persons involved, that's not the task of the journalist, but to bring under the attention the issue in itself. So there was no possibility, just by looking at the broadcasted material, to identify the person, and specifically one person that the police was interested in, that they thought they might recognize, identify, because there was an investigation running against a person who looked very much like the one they assumed they could recognize in the program. And so would you give that footage, the raw material with the original voice and the recognizable image, would you give that to the police, or would you refuse? Yes?
We're talking about child abuse here, so I think it's kind of important that the journalist doesn't forget to remain human in
Yeah.
this investigation, because I think it's a human right that every child should have its integrity, and in this case, I think it's kind of important that a journalist reveals its sources.
Yeah. Yeah, although the report is in the public interest, you say there was a higher interest here because this is a very, very serious crime that needs to be prosecuted, and the persons involved in that need to be brought to court. So there's a higher interest in protecting minors against sexual abuse than public interest of journalists to make such a report. You had the same analysis? Yeah, because it's a kind of a very serious crime. Journalists should reveal the information. Yeah?
I'm not picking sides with the journalist here, but maybe the police hasn't exhausted all the possibilities to find the identities of the people that are portrayed.
Okay.
In the
Interesting. Another additional element. We don't doubt that it's a very serious crime that has been reported, that it could be important under certain circumstances to help the public officials to find the people involved, but that can only be done after the public authorities themselves have sufficiently developed steps already, that they shouldn't start by requesting the journalist to give information. They have to give evidence that they have done their utmost, and that without the information of the journalist it wouldn't be possible to identify the person involved. Would that be a relevant argument? Yeah?
And I'm also wondering, there was a case, I think in the Netherlands, where a pedophile wasn't convicted of actual pedophilia because they hadn't caught him in the act. So the man that made the documentary probably didn't catch them in the act of actually molesting.
No, absolutely not. No, it was just a conversation from which it became clear that he had abused, that he was looking for new context, and that he belonged to a network of persons exchanging information, where in Denmark or in India or in Thailand, how to get in contact, mostly with young boys, to have sexual contact. So you would say, even if he could be identified, that wouldn't be a sufficient evidence for the police that this man could be convicted for sexual abuse of minors.
Or his punishment would be less than he would.
Yeah. I would put this a bit aside, because if he could be identified, they could organize a search, they could confiscate his computer, they could find evidence above the content of the conversation, of course. So it could be an important trace that the authorities are put on by being able to identify the person involved. One more element to take into consideration. This part here has not yet contributed. What could be one other element of consideration? Was this man a source? The one who has been interviewed.
Yeah, he didn't tell the journalist everything with the knowledge that he was a journalist, and the journalist didn't promise him that he wouldn't reveal him.
Precisely. He didn't know he was giving information in a confidential way to a journalist. So that raises the question, can a journalist then in such a situation claim protection of his sources when it is not really a source? Is there an Article 10 issue here? Would it make a difference? So I think we can agree that this is not a pure case of source protection. But still, does it take away the discussion that we just had? Would that material be protected as editorial material, necessary material that you don't hand over to the authorities, unless under very, very specific circumstances? So these were all kind of questions which were at the debate in this case. It refers to these two perspectives that I just mentioned. Yes, you need to be under an obligation to help the judiciary to identify such a person, specifically of that kind of crime. On the other hand, protection of journalistic sources. We have some exceptions for lawyers, for instance, for doctors, but journalists, it's a totally other relation, so that wouldn't work. And then, yeah, here, what could be the reason? Of course, to guarantee anonymity, confidentiality, yes, but is it really applicable here? Protection of whistleblowers, but this was not really a whistleblower here in this case, because he thought he was talking to another pedophile. Okay, the media as public watchdog, they need to play their role, and you cannot create the perception that you are working together with the police. That would be detriment for many activities of journalists if people you are interviewing, working together with, know that you can hand over this information to the police. But that was not the case here either. And so we are here in a specific situation, because normally sources need to be protected, because otherwise there's a chilling effect. Sources would no longer be willing on their own initiative to leak information, because those who leak information, they take a risk professionally, security, intelligence information, many risks are taken, and we don't want that people who are whistleblowers would be less enthusiastic to inform journalists about issues on corruption, fraud, issues of all kind of public matters. Otherwise, there would be a chilling effect, and that's not what we want in a democracy. So that brings us back to the case we just had. We heard a few of the arguments. So the court started also by saying the footages, the images are no sources. But that doesn't take away the protection of Article 10. Still, when a police officer or a public prosecutor requests for editorial information, that's a kind of an interference by the public authorities in the normal work of a journalist. So still, it needs to be looked at from the perspective of Article 10. And here, the court said that indeed there were sufficient reasons why an interference was necessary in the something drops here. In the journalistic activities, it was a major crime, what was mentioned here. And it goes even further. The court said, look, there's another article in the convention, the right to be protected against inhuman treatment. So the state has not only the right, but has the duty to investigate when they know about something that might lead to sexual abuse of minors. They have to investigate, they have to act. So that made that there was a sufficient reason and even a positive obligation for the member state to take action to try to identify that certain person. And then still, source protection comes looking behind the corner again, because the order by the Danish courts was only to give the footage of 1 or 2 persons that might be identified. There was not a request that the journalist would give the whole report and all other documentation which he had used, addresses, telephone numbers, to get in contact with a whole set of persons, because that would fall under the source protection. And so it was a fine-tuned measure with a relevant goal, proportionality principle, because it is a very severe crime. So then you can go a little bit further. And also the argument here, subsidiarity. The Danish public prosecutor could show that they were working on this network, but that they didn't succeed really to get any further the last few weeks or months. So this element of Nordisk film could really be a breakthrough for the investigation. So a fine-tuned measure, a fine-tuned order that could be seen as a sufficient argument to justify the interference. So here in this case there was no violation of Article 10. I would leave it here, because otherwise the other speakers, we began a bit too late, but maybe it's better to catch up, otherwise the other speakers get in trouble. But I still 2 or 3 minutes available.
We have 10 minutes because we actually started 5 minutes.
Okay,
early,
okay.
so
But I'm available for questions or other issues or reflections. Do you think the European Court is sufficiently aware of the importance of some difficult decisions need to be made in order to present in a journalistic way something that can attract the attention of the public on an issue of public interest, the firework case, the pedophiles case, or do you feel there should be other approaches be developed in order to decide on this? Do you think it's dangerous, this way of reasoning? Whatever, observations, remarks. There were some here.
Just a question. Does the European Court have a definition of public interest as opposed to what's of interest to the public?
No, and when you look at the case law over the hundreds of judgments that the court has produced, one can see that the court uses a very broad notion of public interest. It can be very obvious elements, but it can be something which one might argue is not of that central importance, but from the moment there is a group, some region in the country, some issue with some societal or political relevance, then they will say it is of public interest. But you say in comparison of what is in the interest of the public, yes, they make a distinction. There have been several cases in which the court came to the conclusion that although they want to support contribution by the media on all issues of public interest, the media are not there to fulfill the curiosity of people. So when it is in terms of breach of privacy of private persons or public persons even, having no public or political functions or actions which are not related to the public function, then the European Court will say, and I will give two examples or two images in a moment, then the European Court will say, look, here the arguments are not strong enough to invoke Article 10, and then we come with other basic rights. Here we had Article 3, inhuman treatment, the right of privacy. Then it is the task of the authorities, eventually the courts, to protect the rights of individuals against unacceptable intrusion of their intimate life or private life. And just to give you two images to illustrate this, I have it a little bit further. For instance, one clear example is the first von Hanover case, in which Caroline von Hanover brought a case to Strasbourg because in some German magazines pictures had been published while she was on holiday with her children, on the beach in Monaco, horseback riding, being in a restaurant with a friend. The German courts found that this was a figure of actual history, a princess of Monaco, and that it was allowed to publish these pictures. She went to Strasbourg, she invoked her Article 8, right of privacy, and there the European Convention said, the European Court said, yes, it is a public figure, but it's not a figure with political functions. And the pictures are totally unrelated to her adherence of being a member of the, the Kingdom of Monaco. And there the privacy should prevail. The more that the court used also the term permanent harassment, that even when you're a princess or a celebrity, you still keep your fundamental rights as an individual not to be disturbed all the time by others. And that is what was happening. Everywhere she came, and there were paparazzi watching her, taking pictures, and that disturbs the individual life of that person. There was no public interest, there was curiosity for certain, and all the readers of these magazines, they want to see these pictures. But that is not protected under Article 10. That is not why we have press freedom as a very high standard in Europe. And maybe this is a bit in the same area. Paris Match, very well known as a weekly magazine with very strong press photographers. They published of course, an article and a lot of pictures of the assassination of the governor in Corsica about 10 years ago, or even a bit more. And also the fresh assassinated corpse, where the blood was running still, was published in the centerfold of Paris Match, although the family had asked not to publish that specific picture. Because the picture you see here, of course the media, journalists must be able to report about shocking affairs, disasters, terrorist attacks in society. And people have to know, but really the details which were so shocking for the widow and the children, few seconds after the bullets entered into the body of the governor, that they felt was in breach of their personal rights. There was no public interest in showing that particular image. Still they did, they were convicted in France, and here also the European Court said, this is not what we mean with public interest and freedom of expression. Although the picture was closely related to it, still there is a limit that we want to safeguard in terms of privacy, rights of family and human dignity. As two examples of trying to make the shift. In one judgment the court also said journalism is not there to, and Article 10 is not there to support gossip of journalism and to meet the curiosity of the people. But still the notion of public interest is indeed a broad one, but luckily I would say it has never been defined by the European Court. It is a broad notion that has to be looked at in a context and should not be narrowed down anyway, apart maybe precisely from this aspect of curiosity and human dignity. Yes?
We have about
I
three
was,
more minutes. 3 more minutes. Okay.
Yeah.
I was wondering, when you were talking just now, when the police come looking for footage, it is always of untransmitted material, because obviously they've got access quite easily to transmitted material. Not always, by the way, but in the case of the BBC, when the police come looking for untransmitted material, they refuse. But it's very easy in our country to get a magistrate's order to hand over that material, and at that stage, probably depending on the story, the BBC would hand over the untransmitted material. But I wonder what our young journalists today, and you yourself, would think about the editor who, the moment that the programme has been transmitted, destroys the untransmitted material. Do you have a view about that?
Very briefly, because time was too short, but your question is very relevant. The European Court has also extended the protection of sources not only against being compelled, but also organizing searches and confiscation falls under the same protection, and even more, because as you mentioned, a search and confiscation has the risk that the public authorities sniffle even more in information, so that needs even to be more restricted. So then your question is, in order, even if there is a legal protection against that, still it could be under extreme circumstances or the police not respecting the law, they might have the idea to come to the office and to confiscate. So the idea would be to destroy the information. Would that be an ethical kind of behavior?
Yes, if the editor simply removes.
He removes or they hide or they destroy.
Kills it,
Yeah,
destroys
it depends here, I would say. In legal terms, I would say you shouldn't do it if there is a possibility that under the law you can be compelled to give that information, for instance, in such a case where it could help to identify a person being involved in sexual abuse or in terroristic activities. Then my answer would be, then you can be prosecuted and punished, because as a professional, you know that you could be under an obligation to help to reveal, in the interest of justice, to do this.
Well, it's just a fishing trip, though. I mean, very often the police come and ask for footage of demonstrations and protests.
Yeah.
They don't know of an actual offence going on, but they want to have a look just in case there is one that they could use it for.
So in that case, you absolutely refuse. You absolutely make that it's not possible. You make a lot of fuss. You use all the arguments you have in law to keep the police out. If they still would come, if that would be a practice in your country that it is possible, then I think it could be important that you say, look, we know that the legal protection is not sufficient. In order to protect our sources, we demolish, we hide, we make that it will never fall in the hands of the public authorities. Then I would say it's an ethical, justifiable action if you live in such a country where the law is not sufficiently protecting you. But I would say try to organize yourself and take action that there is a better legal protection in legal standards and in practice.
I think it might. I wonder if it might be important to tell our young journalists here why the broadcasters don't want to hand over this material. It isn't just because it hands off its hours, it belongs to us, you don't have the right to come here. As far as the BBC is concerned, it took its view on this because it wanted to keep its camera people as safe as possible, because in our country, when there are demonstrations, the red mist comes over the eyes of the idiots who start tearing themselves and property to pieces. They don't know fear, they don't know right from wrong anymore. And when they see a camera person pointing a camera at them, their idea is to get hold of that camera at all costs. And we have had many cameramen, a number of cameramen, blinded in one eye because the favourite trick is to go to the camera and push hard into the end of the camera. It takes the cameraman's eye out, of course, so that's simple movement. So the BBC's idea for this was that it would bring about some element of safety for its cameramen, because BBC cameramen don't carry a BBC banner on their hat like this, neither do police cameramen who infiltrate the press cameras. So that's why we did it, to try to keep them as safe as possible in a very dangerous job.
And I remember there has been a very recent case in the United Kingdom, I forgot the name, where also some journalists took part in a camp where they, some green activists were, the police came, so they filmed everything. The police wanted to have the images, and also in these arguments they said, otherwise in the future we will never be able to win the acceptance of activists if now we give that information. It's a bit also in line with what you say. It would make the work of these camera teams impossible if they know that they collaborate with the police or with the law enforcing bodies at a certain moment. So that was a kind of a taster of discussions on law and ethics, and I'm sure we will have a lot more this afternoon. Thank you for your attention.